Good morning, good evening, good afternoon, good day, good everything. As you probably know by now, my name is Jason Weiss, and I am the host of the Ask Jason Weiss show. Although I am a licensed attorney, and I have with me today James Keys, who's also a licensed attorney, nothing that we say today is legal advice. Should you need legal advice, financial advice, mental advice, health advice, go see someone directly. However, we are not your attorneys. There is no attorney-client privilege here, and nothing that we say you should rely upon other than if you're thinking about intellectual property, patents, trademarks, and copyrights, which we'll get into, that this is the gentleman that you want to call. So, I know James a roundabout long time. James and I, we have a dear friend who's been on the show before. His name is Tunde Ogunlana. He was on the show. He talked about investing and all of that kind of stuff. And he and James actually have a podcast where they talk about investments and patents and all of this fun stuff. But James is here today to teach us, including myself, what is the difference between a patent, a trademark, and a copyright, and why you need them, why they're important, and how James, unlike me, can help you anywhere throughout the United States. So James is down here in South Florida with me. We've worked on projects together. We've referred clients to each other. And this is the first time we're on the stage together. So, James, without any further ado, James Keys.
Hey, thank you. Thank you for having me. I'm excited to be here.
Dude, my pleasure. So let's talk, let's go back a little bit, right? Okay. So you're in high school, your grades must have been decent. You go to college, your grades must have been decent. You go to law school. Somewhere along the line, you decided, I want to do intellectual property law. When was that aha moment for you?
That happened in law school, actually. So, you lay out the general framework, for an attorney or, anybody who goes through higher education. You do high school, you do college, then you go to a grad school. So for me, high school and college, I did not know what I wanted to do. Now, my dad was an attorney, and so I saw that. He was a different type of an attorney, though. He did criminal law, family law, things like that. He got into estate planning later in life. But for me, my goal, honestly, was to challenge myself along the way because I didn't know where I wanted to end up. And so it was always about, okay, well, what can I do that leans into my skills, leans into my abilities, but pushes me, So I was pretty good in math, pretty good in science. So graduating from high school, I had an opportunity to work. I could go into the business school. I had an opportunity to go into engineering. And so it was like, okay, well, engineering is going to be harder, but it also leans into my strengths in math and science. So I did engineering. But again, it's going to sound like a master plan at the end, but just remember, so I do engineering. I actually do systems and computer science in the School of Engineering. And so I go through that. I have a nice college experience. And then I get I'm towards the end of college, and it's like, okay, well, I'm not ready to work yet. So what should I do? I probably should stay in school a little bit longer if I'm not ready to work yet. So that's where law school came up. Like, oh, my dad's an attorney. That seems to have a lot of autonomy. One of the things I learned when I was in undergrad was that I don't like someone looking over me the whole time. So I kind of like to be able to work in my own space. Some of the internships I had were kind of like, okay, yeah, that's good learning experience as far as what you do and what you don't like. So I go to law school and I decide, okay, law school's hard. So yeah, let me challenge myself. Let me keep going hard. And so even though systems and computer science and law school, there's no overlap, at least that I was aware of, I'm not leveraging my systems and computer science. One other thing, just because of my age, the whole .com bubble burst while I was in college. So, I go in and I figure, okay, these computers are going to be around for a while. So even though the .com bubble bursts, I got to get away from this. It's like, okay, no, I'm sure the things that I learned plus the engineering background will help me in some way. So I'm in law school, and then I summer clerk first summer after the first year of law school. I'm at work clerking at a firm, and they're like, oh, you have an engineering background? You know, you can do patent law. And I'm like, oh, really? Okay, well, tell me more. So so what they explained to me is that in order to be able to practice patent law in particular, there's a license that you have to get from, in addition to a state bar, you have to get a license from the federal government. They call it the patent bar. And in order to even qualify to sit for that, you have to have a technical or a background, which can be a technical undergraduate degree, sciences, math, or engineering. And so most attorneys just don't qualify to be able to sit for it at all. It could also be work experience, though, by the way. So some kind of technical background and a law degree. So these attorneys this place where I was clerking were like, oh, well, you have this thing that most of us can't do. And so they're the ones that connected two and two together. So I was like, okay, yeah, well, I'm glad that although I didn't have a specific plan with it, me deciding to challenge myself in undergrad to get this engineering degree, which it looked like I wasn't going to use at all once I go to law school, now I'm able to put these things together. So that's when the aha moment hit, like, okay, yeah, well, so let me start looking at this patent thing. And so as I finished through law school, it started to be something that I was really looking at.
So it was like a series of fortunate events where it was somebody who told you. So anybody who is thinking that, you want to do something in the patent world, the trademark world, gaming, computer science, and you want to get a law degree, make sure to get that undergraduate degree that might allow you to skip ahead of the line and not have to work in that area. And that's something I didn't know that. I mean, look, I'm not a member of the patent bar or anything, but there's a reason for that, right? Because if I have a patent issue, I'm going to call you.
Yeah. And just to be specific, though, because we're going to get into this shortly. This is patent specific. This is patent, like the trademark. The qualifications won't be the same. The things in order to get into trademark. But patent specific, though, is you have to have this technical background, and yes, a shortcut basically to 10 years of work experience at an engineering firm is getting an engineering degree. And they'll say, okay, yeah, go ahead, and you can sit for the patent bar.
So let's take a step back and let's cover that. I hear it all the time, right? Oh, I'm gonna trademark this idea. I'm gonna copyright my invention. No, like I know a little bit, right? And I could give my 30-second spiel, and you'll say, well, you're kind of sort of right. So instead of confusing the listeners, let's start with what I think is the easiest. And if I'm understanding without getting into specifics, there's three major categories in intellectual property law. There's copyright, trademark, and patents.
That is correct.
Okay. And I believe
to be a little more specific. Let me give you just a little bit more on that, because these things are the nuances, and this will pay off for us later. Those are the three that are centrally administrative. So there's a U.S. Copyright Office that operates out of the Library of Congress. There is a U.S. Patent and Trademark Office. So those three are administrated centrally. Another key piece of intellectual property, and this comes into play with regards to deciding whether you want to seek a patent in some cases, is trade secrets. So you have trade secrets also, which are considered intellectual property, but you don't go to some central body and say, hey, I have this trade secret I want to protect. Trade secrets derive their value from being a secret. You think trade secrets, you think of Coca-Cola formula, so you got to keep it a secret. You don't go to someone else to verify that you can keep this. Like, the whole point is to not tell anybody.
Correct.
So, and there are ways to protect those, but I'll contrast those with patents as we get later on in the discussion. So that's
that's great, because trade secrets, like here in Florida, I know that if you want to protect something as a trade secret, you need to check certain boxes. You need to do certain things. You got to put it time and energy, and it's not just like opening up your phone book and saying, this is my client list, this is a trade secret. No, does not work. But if it's, this is my client list because I've been working with them for 15 years, and I know his daughter's name is this, and her husband's name is this, and that might be protectable. Well, we'll get into that. So let's start with what I feel is the easiest. Okay. Copyright. What is a copyright?
A copyright rights are about expression. And so when you create expression, this expression can be in a book. You can write a book, you can write a song, you can sing, you can perform a song, anything like that. You can do a movie, you can draw a painting, anything like that. So it's some type of expression. Now, by law, computer code is considered expression along these lines as well. So if you are the author of expression, then you then can control how that expression, if that expression, people can make copies of it. hence copyright. And so you are controlling the ability for someone to make copies of your expression and however that would be. And so, yes, but it's about your expression. It's not about your idea in that sense. So because someone writes a movie about superheroes, that doesn't mean that they have a copyright on movies about superheroes in general. That means that story, they're the only ones that can tell. So I can go make up my own story. And as long as it's my own, as long as I'm not deriving it from theirs, then I can get my own copyright on that. So copyright protection is very specific to the expression. Now, it applies also to being able to, if I have characters in my movie, you can't take those and start writing stories about those characters. Like those characters are part of my story. So, but the bottom line is, and where you see this a lot of times is with people creating something, and I want to stop other people from making expression. What you can't do, again, is the key piece, is that you can't protect an idea through copyright, because it's about the actual expression.
Right. So I might be able to write a story about, instead of Little Red Riding Hood, I could do big blue flying cape, right? I mean, I might, maybe, but I guess
to some degree. Well, like when you're talking about ancient stories, copyright rights have a certain period of time where they're protected. But we actually saw in the news, and well, maybe this was like news that intellectual property attorneys noticed, not something on TMZ, but we saw in the news recently, some of the Winnie the Pooh characters were the copyright was expiring for them. So those characters actually, because this is like 1920, something like that, those characters now, either the original stories or those characters now can be republished by anybody else, or the characters can be used. Now, again, this is where you have to get into the nuance of it, because sometimes those characters have continued on in subsequent books where copyright protection still applies. And so what does that actually mean? But so there's this specific duration of time that you have for the copyright, and it gets chopped up and changed depending on when it's created, because they would change the rules for how long the duration of the copyright would be. They've changed it several times over the last few hundred years. So, but nonetheless, that's pretty much what it applies. But that's why you can see oftentimes, though, these fairy tale type stories that have been around for 500 years, you'll have a lot of different people writing those stories or selling books with those stories, because those things, there's no copyright protection on that now after all of these years. So, but yes, generally speaking, if you want to write a story about, we'll pretend Little Red Riding Hood is protected by copyright. If you wanted to write a story about some little girl getting lost in the woods, you could still do that. They don't own the concept of a little girl getting lost in the woods. You would just have to make sure it's a different story. Like it couldn't be the same story, and it couldn't be just, I'm gonna change a couple of names, change this from a river to a stream or something like that. Like it has to be a different story, because again, it's about expression. That's the key word to always keep in mind when you're thinking about copyright.
Now, people will often do it with their manuscript, or do it with a trailer, or do it with this. And if you make changes, do you need to go ahead and register it? So like if I have a story, and it's it gets me from point A to point B, but I decide to change the story and I go from point A to point 2 to point B, do I have to go get it? I do. Okay, I see you shaking your head.
No. What it's one of those. It's a complicated answer, and a lot of times, this is why you gave that disclaimer in the beginning, because fundamentally, not really, but practically, yes. Because one of the bundle of rights that comes with a copyright, again, one of the rights is you can stop other people from making copies. Another one of the rights that you get is you can stop people from creating derivative works from what you've created. So you can create a derivative work. So what you just described there is you creating a derivative work. And and for those that didn't know what derivative work was, that is a spin-off or something that is derived. It's somehow derived from the original work. And so someone can't take and copy your derivative either. The reason why practically the answer is yes is because a lot of times, and this is a theme that comes up in intellectual property, what you're doing when you are protecting your intellectual property, by and large, is you're betting on your success. And so if you succeed, and there are a lot of measures of success. One of the measures of success is, you sell a lot of copies. Okay, great. Another measure of success is people trying to copy you. Correct. If nobody's trying to copy you, then it's like, okay, well, I might have marginal success. But once people start to try to copy you, that's when you've made it. So if that's it, so you're betting on your success with that. So if, let's say, I do have success, well, one of the biggest benefits of the intellectual property protection that's set up and the structures you can take advantage of is to make it easier to enforce and make it so that it's you're more likely to succeed and more likely to succeed quickly, because you don't want to get bogged down in litigation. Or go ahead.
And make money off of it, right? Because
but you can make money off of it without the right, so to speak. You can sell it. It's just the problem, your ability to leverage that.
I meant like if I came up with my book, which I'm going to promote right now, more shit they never taught you in law school. Second book drops today on Amazon, so it's there. But and James is going to get a copy of it, so all that. But so if I wanted to stop someone from using my book, my logo, my layout, I can have them stop because I put it out there, but can I make a claim for monetary damages without a copyright?
Well, no, for copyright rights, to enforce those, you do have to get the registration. You just don't have to have the registration before you actually start enforcing. You just have to be the first one. You have to be the author or the creator or the one who got the rights from them. So
listeners, if you come up with an idea, a story, a transcript, a character, a cartoon, call James and have him do it for you so that you could protect it, because it's not very expensive to protect it, but it's very expensive later on if you don't have the protection. So that's what you want to do. You're betting on yourself, and put away a stack of hundreds so that you could pay James to do it, to pay the fees, to do everything. And when we get into patents and trademarks, that's when you're going to have to make it multiple stacks of hundreds. Copyrights are the least expensive. And there's also an old urban legend or a myth about copyrights, right? And we were talking about this right before we went on the show. So I'll let you explain that.
Well, okay. So the old urban legend or myth, or just the poor man's copyright, was always termed as you put the expression or a copy of the expression in an envelope, you take it to the post office, buy your postage, you mail it back to yourself. Then you have this thing, a sealed envelope with a postmark on it that says you were in possession of this at a certain time. Now that can have some benefit, because if there's ever a question of who came up with this first, who I wrote my story before you, and so, therefore I should have the right to be able to protect it, whereas you came after me, or you saw it and then copied mine. So if there's ever a dispute like that, maybe that can be evidence. The issue is that for copyrights, you have to have the registration to actually enforce it. And so now sometimes you can go get the registration, I should say, after someone's already started copying you, but that makes it difficult to get damages or anything like that. So that's something to do. And then the point being is that anytime you're getting these intellectual property rights, what you want to be able to do is to make it quicker and more easier, less expensive to enforce. You spend a few $100s trying to secure the right for the copyright. You spend tens of thousands or hundreds of thousands trying to protect it if you're in a fight in litigation with someone. So the more things you can do up front to make it so that if you end up in litigation, it's short and it's not that expensive, and you're going to have a better chance to win. That's really the game that you're playing. I'm going to spend $1,000 now so that if I ever get in a fight, I'm not spending 100,000, I'm spending 10, and I'm winning. I'm winning clearly, and I'm winning decisively. And that's the reoccurring theme you're going to have with all of these intellectual property rights. Back to your point, I know we want to take a break in a second, but back to your point or your question, but your question about if you want to like whenever you look at it, I lost my train of thought on that one. But because I did want to touch back on when you asked me about I lost my train of thought. I don't
having to do with damages, being able to claim the damages and make money a claim.
Well, yeah. Well, the damages. What I was going in with that was just that there are certain legal requirements in order to get the damages that you have to make, and one of them is like that's where you can't come behind after somebody's already enforced or started it, and then get your registration. You can still be able to stop them from doing it, like you said, but you have to set up the damages claim. So that's another thing that is very important, because what you can do is if you have a damage claim that's viable, if you are able to not only get people to stop, but also get them to have to pay you money when you go after them to enforce, that's a much bigger hammer. That's a much bigger hammer to come after somebody with and say, okay, here, I'm going to make you stop. And they're like, oh, we'll take our chances. I'm going to make you stop, and I'm going to make you pay $100,000. Just like, oh, well, maybe we need to... Again, quicker resolution, less money being spent on your attorney during that time. And the derivative work piece. So that's where the streamlined version of should you get another registration? Probably, because the registration is a few $100. Whereas if you're trying to enforce it, if you just say, all right, here's the new registration, that's much cheaper than having your lawyers make some argument. Okay, oh, well, we have the registration on the original one, and then we have this one's a derivative work, and then we're proving all this other stuff about your lawyers have to basically prove a lot of stuff versus here it is, boom, copy, done deal. And so one of those is much more expensive and much more tenuous than the other. So let's spend $100 more or a couple $100 more, get the straightforward, clear claim so that we can save thousands of dollars later.
And the other thing that we were talking about, and you talk about with derivative works, and you have protection, right? All the time, I'll watch a movie and I'll be like, "Oh my god, Now You See Me," right? One of my favorite movies, and I think they're coming out with a third one.
Yeah.
There's a part in the second one where they talk about Lionel Shrike's body never being found, and what I always wanted to do is make a movie about how Lionel Shrike was hiding in the shadows and doing all this, but I can't.
Correct.
Because they own the rights to that.
They owns the right, and that would be a derivative.
That would stop me. So what we're going to do is we're going to take a 25-second break where we're going to thank our sponsors and we're going to run a commercial, and then we're going to come back to intellectual property, and we're going to move on to the second the middle level of complexity, which is trademarks, and then we're going to spend our time on the hardest SOBs in the world, patents. So we want to thank Going Bold Network. We're going to see a quick commercial, and we'll be back in 25 seconds. See, 25 seconds and we're back. I want to thank newstreamingnetwork.com for that awesome commercial and that advertisement, and for supporting us in the show. And I want to put the disclaimer out one more time, because we are talking law today, that despite James and I both being attorneys, nothing we say today is legal advice. Should you seek legal or financial advice, consult an attorney directly. And this also applies to the intellectual property tutorial that we're getting right now. So we just covered copyrights, which is basically art, pictures, stories, Little Red Riding Hood, Now You See Me 1, 2, and hopefully 3 coming out soon. So now we're going to move to the next one, which is a trademark. A trademark that we see every day all over the place is probably the Coca-Cola can.
Yeah, that might be the most popular one in the world, or at least it has been thought of, traditionally considered one of the more popular brands in the world. With the tech world now, that may be different. It may be Google now, or it may be I don't know.
So what is a trademark?
All right. So now remember, with copyright, the key word I gave you was expression. So with trademark, the key word or the key phrase is source identification. It identifies the source of some good or some service, or a collection of goods or services and so forth. The trademark is how you communicate who the seller is. Who am I doing business with here? And so it's a brand. It can be a name. It can be a logo. It can be a color. If we're talking UPS or something like that.
Right.
There you go.
Right.
And so with
it's a color, right? Isn't the Tiffany?
Oh yeah, Tiffany. Blue? Yeah, we got blue. And that now those are really, really hard to get. But yes, you also can do that. And now one of the key things to know about trademarks, though, is that the rights themselves. The rights are there for a public benefit, and then in the way the government and the system is set up, in order for the public to get this benefit of knowing who they're doing business with and not being confused about, are these people related to these people, is to make a private right that people can then enforce and then can derive a lot of value from. So. But trademarks, you don't get to own a word or own what you can do is you have a name or a logo or everything like that, and you own the rights to use that as a source identifier with certain whatever goods or services you're doing it with, or anything that could be confusing with that, though. So it's not like, I can own the word Pandora for internet radio. Well, it's like, no. There's somebody else that has a trademark registration for Pandora for jewelry. So the two people can have a trademark that's the same word, but the thinking is in that sense is that people aren't thinking that the guys who are doing internet radio are also selling, bracelets, so what they're doing is so different that the rights can exist. But the key piece, and a lot of times that's one of the first things I talk about with people is that, like, I want to own this word so that nobody can ever use this word without paying me. And it's like, well, no, what you can do is own branding, own the way of identifying yourself so that anytime somebody sees this X brand in connection when used in this context, they know it's you.
Right. So the shape of the bottle where it goes like this, right? I think Coca-Cola owns some protection on that because of the shape of the bottle, if I'm not mistaken.
That goes into
trade dress.
Trade dress. Yes.
Yeah.
Yes. I apologize, but I got to be a little technical with it.
It's okay. So wait. So let me ask you this question, and I remember this from law school 25 plus years ago. The likelihood of confusion.
Oh yes.
Where does that come into trademark?
Yes.
Okay. So explain that so that when people are, and I think to me that was always like the good baseline. It was always a likelihood of confusion that if I were to hold up this marker and this marker, there's a likelihood of confusion because they're very similar. But if I were to hold up this marker and this scissor, probably no likelihood of confusion.
Yeah. So likelihood of confusion is that's like the holy grail of trademark law. Like everything is determined based on the rights, the infringement, all that stuff is determined on whether there is a likelihood of confusion. So when you have trademark rights, and let's say, okay, so and so has a brand, somebody makes Ford cars, for example. They have a brand Ford and they make cars. So the question is, one, it can be looked at it two different ways. How close can I, let's say I'm making cars, if my name is too close to Ford, then if it's pre-Ford, if I just put a PRE in front of it, is confusion likely? Is it likely that consumers will think that those two businesses are related? Either they're a part of it.
Yep.
That's the analysis to determine if there's infringement.
Correct.
So
if you have a blue logo and you add an E to Ford and you put it on cars and trucks, you're gonna be stopped by Ford. But maybe if you have a square logo and you add the E to Ford and you're putting it on, I don't know, a mouse for your computer, you might be good. But
that was going to be my next example. So it's how similar are the marks, and then how similar are the goods or services. So if I'm going to do Ford and I'm going to sell hamburgers, then I'd probably be okay, because it's like, well, hold up, people aren't going to think that you car company are over here selling hamburgers too. Right. So that's where you get into the question of likelihood of confusion. And the two main factors are how similar are the actual marks, whether it be now trademarks. You mentioned the actual, now we're not touching on trade dress yet, but looking at trademarks, when we're talking about, you can protect the text alone, or you can protect a design or a design with text. And one example I use for this is Coca-Cola. Actually, Coca-Cola will have a trademark registration, and we'll talk about what that means shortly, but the registration will cover the wording Coca-Cola no matter what. And so any format, this text, we want to protect that. But they'll also have a registration protecting Coca-Cola in the script font that they put on the side of the bottles and the cans. And the point, those are overlapping, but they also protect something different. If I only have the protection for the script font, and if I'm going to say I'm going to do Coca-Cola, but I'm going to put it in a completely different font that looks nothing like that, that would be a harder case for them to make because they only are protecting the impression of the wording in that font. Whereas if they have the wording protected, it's open and shut case. It's like, okay, boom. Again, instead of spending $10,000 on attorney's fees or 20 or 50, you're spending $1,000 because it's just a much more direct shot. Conversely, no matter when you have the protection for let's say you have the protection for that script font, and I write Jason Cola, but I write it in that exact script font and it looks just like Coca-Cola, even though it's not the same word, they still might be able to protect that because it was like, hold up, you made the text it looks like Coca-Cola. And even though actually, if you really get in there, you're saying it says Jason Cola. So the ways you can protect what it is that your branding is, there are varied ways. And I mean, that's why, it requires, best advice is always to say, okay, yeah, you should talk to somebody about this.
Yes, because you also have certain classes you got to register it for. Like if you want to take the Coca-Cola logo and put it on a hoodie, you probably have to register it in hoodies, athletic wear, shoes, all this and all that. So copyright, look, the Florida bar would always tell us, anytime you're doing anything in legal, you should hire an attorney. Copyright, you might be able to learn, maybe. Trademark, don't even try. There's too many nuances. You have to hire an attorney. And for copyright, you should hire an attorney too. Yeah. Now, the hardest one,
real quick, let me throw something at you real quick. I sometimes I like to quote my Chris Rock jokes, and it's really the trademark thing you could figure out, but it's kind of like driving a car with your feet. You could do it, but it's just not the best way to do it. There's a lot of things that can go wrong, and so that I every now and again just throw. Chris Rock gives, I think the comedian has some wisdom in his jokes sometimes, and so yes, you could figure out how to do the trademark, but the issue really is that things you don't know. You're kind of making decisions that could really matter, not because you knew about it and you decided one way or the other, but because you didn't even know that by checking that box or by doing it this way, that implication is going to be, okay, 5 years from now, if I need this thing, then my attorney's going to be telling you, oh, well, we can't say this because you went about it like this then. And so it's that what you don't know can hurt you when it comes to protecting these trademarks. And again, if you're just betting on your success, if you're just trying to make it easier and cheaper, if somebody comes around copying you, then you don't want to be penny wise, pound foolish as far as missing something. And again, not because you weren't smart enough, but because you just weren't aware of all of the little things, all these little arguments that could come up later on.
And it's not an intelligence thing at all, right? You take your car to the shop. You don't tell the mechanic and say, oh, it's this, and this, and this. No, you go to the mechanic and you say, when I step on the gas, it's not moving. Or when I turn the wheel, it's making a thump, thump, thump noise. And they do it. So it's, hey, I have this idea. I want to protect it. Help me. And that's why they come to you. So
and those were really to get the benefit of I've seen a million ways that things have gone well and things have gone poorly. And so it's to get the benefit of that and say, okay, well, when I saw this happen, it didn't work out well. So we want to avoid that pitfall and anything like that.
And now the hardest of them all, a patent.
Yeah.
And we've worked on patents together, meaning that I came with clients that had ideas and we needed a patent. And I was the smartest guy in the room to say, I don't know what I'm doing. I ain't going to do it. I'm not licensed. Hey, James, let's talk. So come up with an invention, right? Did we ever get that patent? We got that patent, right?
Yeah.
Okay, so we could use that if we want as an example, if you'd like.
Well, I think we can talk about it generally also.
Go ahead. Go for it.
And the key word for patents, we have expression, we have source identification. Patents, you've already said it, it's invention. You've created something. And this is new, and it's never been out here before. It's not that, oh, well, I had this chair and now I figured out how to use this exact same chair for something else. It's not a new use for an existing thing. You created something. Necessity is the mother of all invention. Well, yeah, you saw that whenever I try to do X, this other thing happens. So you changed what was happening, or you changed the structure of something, and then now it solves that problem. So with patents, what it is in order to get a patent, now unlike copyrights and trademarks, but with copyrights and trademarks, you actually can have rights that can be enforceable without going to the government and saying, hey, register this for me. Those are registrations, copyright registration, trademark registration. With patents, there is no right unless and until the U.S. Patent and Trademark Office stamps you and says, okay, you have a patent. Those rights are not something that can exist, quote unquote, in nature, so to speak, or at common law. The reason being is that it is an exceptional right. We live in a system that is based on a market economy. And in a market economy, if people want something, the market sends a signal to other people to start selling it, to enter into competition. That's the way the system is set up. That we find increases innovation and keeps costs down, and then makes people do better and do better and do better by having this competition. Well, patents allow you to opt out of that. And so that means that what a patent right is, you don't need a patent to sell anything, but what a patent right is the right to stop other people from making, selling, or importing what it is that you've had patented. So there can be all the signals from I'm making millions of dollars selling this, and everybody wants to get in and say, oh, well, let's sell our own version. And it's like, well, no, you can stop them from doing that. So it can be a very valuable right. And the way I describe it really is it's a multiplier of value. It's a multiple for you. And so if you can sell something for $10 without a patent, you can sell it for $100 with. but you still got to be able to sell it for 10 first. If you can't sell it at all without a patent, the patent's not going to make it more valuable because the marketplace determines how valuable it is. The patent just will multiply that. And, go ahead.
So I have a question on a patent. If I were to take a marker and attach it to, you can't see it because of that's weird. There's no background on here. Wow, that's really weird. So anyway, so if I take my this and I add my pencil to it and I add a pen to it, and each of these have its own protection, right? They're each on their own, and
those are probably public domain. But
right. Yeah. But like, if I were to use something that's out there in the public domain, right, and want to come up with an invention, and instead of doing something brand new, I take something that's out there and I include it in mine. Am I able to get a patent protection on that?
Yes, and in fact, that is really what the patent system is trying to encourage. It wants you to take what's out there and improve upon it. One way to improve upon it is to make changes. Another way to improve upon it is to add things. So you can say, okay, I'm going to take this component and combine it with this component, and then I'll try to get a patent on that. The key piece there being nobody's ever combined those two before, which, right. that's unless you have the need, it's hard to see that in the abstract. And so generally speaking, the patent analysis accounts for that. The two things they look for is it new? And really, is it new? And then is it new enough? And that, which legally it's like novelty, non-obviousness. Gotcha. But is it new and new enough in the sense that, can they find something? And it could be anywhere in the world, anything that's ever been published, anywhere. Can they find something when you apply for the patent? They're looking, can I find something that has each of these components? So, I have a widget and it has component A, B, and C. A, B, and C all existed before, but they had never been put together in a single thing. And so, okay, so I have that. That would be novelty. All right. Nobody else has people put together A and B, people put together B and C, but nobody's put together A, B, and C. So that's novelty. You're halfway there. Not really. The hard one is the new enough. Is it obvious or non-obvious? And you have to be not an obvious combination or modification of known things. And that's where, we just end up fighting with the patent office all day, because what's obvious in hindsight is always, everything's obvious in hindsight. Once I explain it and say, okay, here's the invention and here's how it works, and this is why it's great, then, oh yeah, well, of course, anybody would have done that. Right. It's like, well, no.
Wait. Of course, you take a bread tie and you go like this, and it's all of a sudden, of course, that's obvious. You get it at. That's crazy.
But so the courts have constrained the patent office and have constrained the analysis, because anything can get lost in obviousness. But the whole point being, and this is where I said new enough, it's okay. Well, why is this different? And then why do those differences make it better? If you can articulate why your differences make it better, then that refutes the idea that it's obvious. Because if it's all these reasons why it's better, then it couldn't have been obvious if nobody ever did it. And so that's how you're looking at it when you're, patent standpoint. But it's encouraging you to take what's out there, improve upon it, whether by just modifying it or adding different stuff to it. And that the purpose of that from the government standpoint is to encourage innovation and to have people make their innovations public. What they don't want, the reason why this exists, is because they don't want people coming up with all this new stuff and then keeping it all private, keeping it secret, because that doesn't encourage, from a societal wide standpoint, innovation, which is, where you end up back at that trade secret thing. The difference between a patent is, in order to get this right of exclusion, they'll give you a 20-year right of exclusion. In order to get that, you got to explain how to do it. And that's going to be public, but you only get to 20 years, but that 20 years, you can really leverage it. For the trade secret, the whole point is you have to keep it secret. But if you can keep it secret and somebody, if you can keep it secret, then you can keep that protection forever. The difference, though, is that for patents, if somebody can reverse engineer what you've done, if they can come out with their own way to do it, you can still get them with the patent. Whereas trade secret, if somebody can reverse engineer it, the crime with trade secrets is misappropriation. Somebody has to steal it from you in order for it to be something the law will do about. If I can go in my lab and figure out a way to make Coca-Cola formula or make something, and I didn't steal anything I didn't go get any designs from them or anything, nothing they can do about it, because that's a trade secret. Whereas patent, if they had a patent on something, it doesn't matter how you came up with it. If you are doing what it is that I have patented, then I'm shutting you down and or getting a license from you where you're paying me for each unit or whatever.
So and this is a question that a client and I were talking about yesterday, to be honest. He went into ChatGPT and he said, I want to have a picture of a yellow highlighter, which you can't see because it's yellow, a white highlighter with a pink cap, and it came up with this picture. Mm-hmm. And can he now get a copyright, a patent, or a trademark on the picture that the AI came up with?
Yeah, that's going to be that. This is still fights being happened. Now, the nature of what you're talking about would seemingly be, if it's a picture, then we're talking copyright because that's an expression.
Okay.
So,
right.
But if you're saying let's say you had the
no, let's do it as a picture. He went in and said, "I want a yellow highlighter with a pink cap," and they came up with it.
The question at that point, was he the author of that picture? And that's the open question right now. I don't think that we have definitive answers right now, though I would say we lean towards no, that he wasn't the author of that. He just gave prompts and something else was. Let's say you had a 3D printer, though, and he printed it. And let's say nobody had ever created a pen like that had whatever features we want to articulate. Then that gets into the question of patent. And it's like, okay, well, hey, did I really design it? Am I the inventor? And so, but these are questions that I'm not going to tip the hand, so to speak, because I don't think that it's 100% certain yet. Right now, the bias is towards, once you're using consider machines as tools, as a hammer. It might be a very potent hammer, but it's a tool. The extent to which you're using the tool versus the tool doing the work. And so that's where there's going to be a more clearly defined line in the future. I don't know that we're there yet, but right now, I don't know that would be a feature that you would want to highlight if it's, I didn't really do it. Actually, the AI system did it. The chatbot did it or whatever.
So, James, we're almost at the very end of this show. If people want to reach you, what's the best way for them to reach you?
Okay. Best way, all of my contact information is on my website, Keys Law Firm, which is KEYS, like car keys, house keys, keyslawfirm.com. That'll have all my information there, including an email address, a telephone number you can reach me at. And yeah, so just tell them, I'll definitely take care of you. Tell you heard about me on the show.
And and for the viewers that are watching, it's along the bottom right now, keyslawfirm.com. And James, and any parting words of wisdom to aspiring either attorneys or inventors? And you got 30 seconds because then we're going to be cut off.
Okay. All right. So what I'd say for inventors, definitely keep trying to solve problems, keep trying in businesses, keep trying to create new and to build something new. But as you do it, know that, bet on your success, the things, if you're doing something better, then figure out a way that you can protect it. And the best way to do that is talk to an attorney. And, for attorneys, let's keep figuring out ways that we can help the public and help keep this business along. The legal field, we are a companion. We help people do amazing things.
And because James is registered in the Federal Patent Trademark Office, it doesn't matter what state you're in, unlike me, where I can only represent people in Florida and Washington, D.C. James can help you with your patent anywhere in the United States. Yes. So, got a patent, got some copyright, got some trademark, got some intellectual property, want to know more, and we're intrigued by this, go ahead, contact James, again, at www.keyslawfirm.com. I want to thank the new streamingnetwork.com for sponsoring the show. I want to thank our listeners. I want to thank everybody, and we'll see you again in 2 weeks. Everybody have a great and stay cool, stay warm, stay dry, stay good.
All right. Thank you.